Time for another installment of Martial Law with Marshall Chriswell, and this program intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. You should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is with us this morning. Good morning.
Good morning.
Good to have you with us. We started a conversation last time about confidentiality and the particular rules or norms that govern the actions of attorneys in terms of protecting their clients' information. And the genesis for that conversation was the Michael Cohen situation.
Right.
And so I thought we'd expand on that conversation a little bit more, your philosophies and the particular legal barrings, if you will, for the information that you may release. And you were very specific last time, having to do with criminal conduct, as I recall.
Yeah, that's right. So when we're talking about confidentiality of client communications, client information, really that is that rule, that ethical responsibility of an attorney is really a cornerstone to our whole legal system. It's so important that there really are very few exceptions to it. The general rule is any information that I obtain about a client during the course of my representation, whether it's something the client told me or something that I obtained on my own through my research or investigation, any client information is subject to the rules of confidentiality, and neither I nor any member of my staff or anybody that I contract with or hire to work on a case can disclose that information without the either express or implied consent of the client or some other exception that may apply, such as what we talked about last week, which is criminal conduct. If you're aware that your client may be engaging or about to engage in criminal conduct that could cause bodily injury, property injury, or some other kind of damage, there's an exception there. And there are several exceptions to the rules of confidentiality, but they're pretty narrow in scope. And it's really important to have these confidentiality rules so that clients can be as full and frank in their discussions with you and have full confidence that they can proceed with a case. And that not only protects that particular client, but also our legal system in general.
One of the things about the Cohen case that stood out to me was the fact that they did not just seize records in that case. They seized everything they had, which exposed other clients, I would assume, to police perusal or law enforcement perusal of other records that had nothing to do with them. They could do it under the idea that, we're checking to see if the trail leads here.
And they would have had to have convinced a judge that those measures were appropriate under the circumstances. That and probably and we're not privy actually to all of those arguments and rulings, but I'd imagine that they made a case, an argument for that by saying that it appeared that Mr. Cohen was engaged in kind of widespread involvement in these fraudulent activities, and that they needed to look at other client files because things could have been mixed in. Things could have been, you can pull something out of one file and put it into another and say, okay, that file's confidential and you can't look at that one. So he could have hidden things in other places, and there could have been other other clients and other matters that were involved. So, but they would have had to make a very strong case to a judge to be able to do that. And then also the judge in those kinds of situations is going to put very strict rules in place, I'm sure, to say, okay, well, this is who's going to be able to view these documents. This is how long you're going to have them for, and anything that is reviewed needs to be cataloged, and we need to create a record of that, and it's not going to leave this circle.
One other aspect of that particular case, and emphasizing, of course, that that's an extraordinary case. It's not the way things are typically done.
Absolutely.
Was the fact that he recorded conversations with his clients down through the years. I don't know if it was particularly with one client or with all of them, but that is not standard practice, is it? Is that even legal?
Well, I don't know what the rules were in the states where he was providing his representation. In Pennsylvania, first of all, you have a two-party consent rule for any recording of any conversation. So if I'm going to record a conversation between you and I have to get your permission first. I at least have to tell you I'm recording the conversation, and you need to impliedly consent that I'm allowed to do that. So that's number one, just a general law called the wiretap law. But then, in addition to that, there are client confidentiality rules. Are there some times when attorneys might record their clients? Yes, there are, with their client's permission. I record clients sometimes when I am involved in a very detailed meeting with them, and I'm not sure that I'm going to be able to capture everything in notes. Mm-hmm. So I would obtain consent to record a conversation so that I can go back and review it later on. Also, sometimes when I'm preparing an estate plan for a client and there's been a question raised as to the client's mental capacity, I may want to record that conversation in case we would need to use that later on as evidence that the client did have mental capacity when they signed their will or their trust or other estate planning documents. So, and I would obtain the client's consent to record that conversation. So there are instances where you would do it. In this case, it sounded like he was recording conversations without the consent of his clients and without their knowledge, and for other purposes. So it certainly didn't sound like something that was customary or would have been proper under Pennsylvania law.
Yeah, it's always a two-way street.
Right.
By the way, I'm recording this, and we're going to post it on here on our website, as we always do. And granted, this conversation today, the one last time, they're not typically what you and I get into in this conversation on this segment we call martial law. But there was one other aspect away from that case, and it happened over the weekend in the Rossfeld trial in Pittsburgh, and that was that after the verdict was read and the situation developed as it did Friday night, Saturday morning. It's still developing even today with protests that are planned. Yeah. Somebody went and shot up the lawyer's office.
Right. Right.
We need to be aware always that, most people, 99.99% of people are going to have cool heads and they won't pull a trigger. But that seems to be less and less the case recently, that more and more people are pulling out the gun if they disagree with something. And I think it's time for a cautionary note from the attorney's perspective of it's a dangerous occupation, or can be a dangerous occupation, particularly if you get involved in criminal court.
It's it really, and like you said, it seems more prevalent, recently that people are taking kind of justice into their own hands and pulling out a gun or whatever it is, and attorneys find themselves in these involved in all kinds of cases where it's not just criminal law. Obviously, that's an obvious one. Domestic family law cases. I bet that the and I've heard of so many in just the past few years, attorneys being attacked, being shot, being killed, even in domestic family law type cases. That's a big one. Even property disputes and things like that. You find yourself involved in these highly contentious matters, and you've really got to look out for, attorneys have to look out for their own safety as much as, and we don't think about it that much because we're so concerned. I think, at least from my perspective, I'm always so concerned with making sure that my clients are protected. Mm-hmm. And a lot of times you don't really think about your own safety, but you really need to. And then something like this Rossfeld case, where not only do you have the parties involved and their families, and it's highly contentious, but then you have, it's on a much wider scale because the case was so public, and the crazies are going to maybe come out of the woodwork. So,
well, you do make a great point, and that is that even in civil law and in cases where we might not consider it to be so, emotions can get the best of people, and if those people are a bit unstable, then there can be danger, and for all the folks surrounding them, there's a danger involved as well. So folks need to be clear-headed about this, and well, part of what you do is you seek to find that ground that is going to be stable on all sides, and people can have confidence that we're going to get to what is fair and just in every single case.
That's what we try to do.
All right. Well, he's Marshall Chriswell with us here this morning on Indiana in the Morning, the voice of Indiana County. I'm going to lose my wind here for some reason. So as we move forward and we think about some of the issues that we've been talking about here today, folks can remain confident, I guess, that attorneys are going to be looking out for their best interests, and that what they say to their attorney within the four walls that they are sitting with that attorney, they can be very confident that it's between you and them.
That's right, and like I said, there are, as far as client confidentiality, moving back to that topic, there are rules in place that provide that confidence for a client. In our office, there are all kinds of things that we do to protect confidentiality. From ensuring that other clients, that may be in the office aren't hearing, confidential communications, conversations with another client, ensuring that our files are protected, ensuring electronic communications are protected, all kinds of things that you have to do to comply with those rules. It's highly important.
Yeah. Yeah, I took us down a side street there for a couple of minutes, but I wanted to swing back around to where we began the conversation. Okay, people want to know about you and maybe find out what you can do for them. What do they need to do?
You can always call at 724-465-5826. Come see us in the Atrium Building, downtown Indiana, or get on the web and find us at www.westernpalawyer.com. And I would add that if anyone out there has a topic that they'd like us to cover, I mean, we've been doing this at least a couple of years now.
You've been over in the other studio. So this is 6 or 7 years.
Has it been that long?
Yeah.
Wow. Yeah. So if folks we've covered a lot, but if folks have things that they'd like us to cover, go on the website, westernpalawyer.com, hit the Contact Us button, and send me an email, and we'll try to cover it on the show.
There you go. Sounds good.
All right.
Sounds good. We'll
Thanks.
see you in 2 weeks.
Okay.
He is Attorney Marshall Chriswell with us here this morning on the Voice of Indiana County, WCCS AM 1160 and 101.1 FM.